Group settlements. We know that there's a statute in Texas, a case law involving the guidelines for group settlements. There are the ethical guidelines throughout the country. What are you seeing in your courtrooms today?
First, the ABA is currently looking into amending the model canons of ethics that relates to cumulative settlements. And if you're interested in this, go look at the ABA website. Secondly, if you are in any state and are considering either making a cumulative offer or accepting a cumulative or making a cumulative demand, do not walk to your casebook and go read the case Burrow versus Arce from the Texas Supreme Court, approximately 1997. If you're the plaintiff, the case holds, and it's now been adopted by the Superior Court of Western Pennsylvania.
No.
Yes, they have.
Allegheny County.
Okay, well,
Trial court.
no,
We don't have a Western
Okay,
court.
well,
we just
whatever.
have a whole court.
Fine.
Somewhere in Pennsylvania.
Somewhere in Pennsylvania, it's now been adopted. Making a cumulative demand and accepting it is a breach of fiduciary duty. And assuming there are no damages, assuming the plaintiffs end up with more money because of the cumulative demand, makes no difference, because the Texas Supreme Court the remedy is fee forfeiture in the absence of damages. Do you get that? Fee forfeiture. Now, here's the really good thing. The same lawyers that brought the original Arce versus Burrow suit, and I was the trial judge in that case, are now bringing lawsuits against defendants for conspiracy to enter into breaches of fiduciary duty between the plaintiffs and the defendants. Now, I'm not saying there is such a cause of action, but if you're representing a defendant, you don't want to get hauled into another lawsuit in 3 years between the plaintiffs and their current attorneys. Watch what you do on cumulative offers and demands. What I always hear is, well, we can't move our dockets without cumulative offers and demands. And last time I checked, economic necessity is not an exception to the canons of ethics. Or apparently to the cause of action for breach of fiduciary duty.
Can I just ask Judge Davidson, does it make a difference if during this cumulative settlement both parties evaluate the value, put a value on each case in the cumulative settlement?
Well, no, that makes a big difference. If there is a discrete demand made on behalf of each plaintiff, that's not a cumulative demand.
Exactly.
But if the person says, I'll give you $1 million or give me $1 million and I'll divide it up between my clients as best I can without pre-consent from your clients as to what you're going to take, or if you've gotten one of those funky powers of attorney that says you can settle a case without your client's consent and you go and do so on a group basis, if you're in Texas, thought about Texas, are representing a Texan, ever flown over Texas, you might get hauled into a Texas court and given and charged with violation of Arce.
I think we all agree with you, I think, in concept. In Pennsylvania, it would be wrong to say, I'll give you $1 million and you divide it up. But like Judge Stack said, if the plaintiff's lawyer has talked to his 10 plaintiffs in that group, and 3 of them want $20,000 and 2 of them would take 10, and et cetera and so on, and he adds them all up and he goes to the defendants and he says, okay, we'll settle this package for $150,000 and this is how my clients have agreed to divide it up. Each one has agreed to take X amount. You add them up, you get $150,000, give me $150,000, I'll go home. I think that's perfectly fine and perfectly ethical, because what they've done is they've contacted the 10 people, they've gotten authority for 10 separate figures, they've put them together and made, if you will, a cumulative demand as to the whole number, but not as to individual parts.
I got a question. What's the ethical problem if the cumulative offer is contingent on each defendant accepting? In other words, it's $1 million. It's $1 million for 10, and each of your plaintiffs have to take it. If one of them bails, then the other ones don't get paid.
Yeah, the ethical rules say that as long as you notify every one of your clients about the total overall amount of the settlement and then what each particular plaintiff is getting, and they all consent and approve,
You left out one
it's a disclosure issue.
You left out one phrase. And the reason for the one person getting more or less. So a person comes to you and says, but Perry, I need another $50,000 from everybody else because I'm impotent. It's brought impotence on. This terrible asbestos disease has brought impotence. So now you've got to go to the union hall and explain to everybody that the reason old Joe here is getting $50,000 more than everybody else is because he's impotent. Well, what happened to attorney-client privilege? I mean, there's an inherent rub on the obligation that's in the canons to explain to each person the reason for different settlements.
I wasn't going to leave it out. I was going to actually highlight it because I was going to say that, and the criteria for paying each claimant a specific amount. Because, first of all, pragmatically, when you're speaking to a client and you're explaining to them, you know, how much money they're going to, you know, the offer is, you are explaining to them the reason why they're getting that offer and, you know, what their damages are, how long they're paying. So that is done. We in New York also use a special master that we create a criteria with and who actually approves of the settlements. So that there is a completely separate scenario there too. And I think that that's helpful for people if they do group deals, but I don't think that the group deal.
The key element is disclosure, so notwithstanding the fact that counsel may have had the approval of each one of the plaintiffs for a certain settlement sum, and if they're all tied into this deal, all or none, then if one plaintiff is a holdout looking for an extra sweetener, and the defendant is willing to pay the extra holdout money, then there really has to be explained to each one of those plaintiffs that this one plaintiff is the holdout and the plaintiff is getting extra money to close the deal. And all of them have to agree for that particular extra sweetener for that individual plaintiff.
Don't get me wrong. I was the trial judge in RC. I dismissed the case because I said no harm, no foul. In the absence of damages, there is no relief. And I got reversed by the Supreme Court for it. And there were egregious facts in RC. But for your purposes, the word group, the word cumulative shouldn't be in your written offers or demands or in your vocabulary, because when the lawsuit gets brought against you and you seek a summary judgment, the word cumulative, the word group in your demands, in your emails, in your exchanges defeats the summary judgment that you will be trying to get. And I know those of you that are plaintiffs' lawyers hate summary judgments. Well, you'll love them plenty when you're the one being sued. You know, if you use certain buzzwords like that, you're begging for your summary judgment to be denied. But if you've talked to, like Judge Stack said, if you've talked to every one of your clients and you know what they'll demand, just make discrete offers. The other side can add. Most defense lawyers can add 10,000 times 10, right? You know, so you don't need to do that in order to settle the case and get your summary judgment when you're sued, if you are.